Ladies and gentlemen, thank you for taking the time to be with us today and welcome to the In-House Council Forum program and our third webinar in the series. My name is Vidushi Gupta and I'm a partner in Khaitan's corporate and commercial practice group. I would like to extend a very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. The In-House Council Forum program is designed to provide training and education in legal operations, business, management, and substantive law relevant to General Counsel and their in-house counsel teams, as well as a discussion forum on contemporary issues relevant to the in-house community in India. Our subject today is labor codes in motion: what's notified, what's next, and what to do. On this slide is the agenda for today's webinar. In summary, we will have an expert panel discussion followed by a Q&A session with audience questions. We have already received several audience questions, and if you do have more questions, please submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation, summary notes of the discussion, and a recording of this webinar will be sent to you after the webinar as a matter of course. To set the context of this webinar, employment law in India has traditionally been governed by a highly complex and layered regulatory system. Unlike jurisdictions where labor regulation is largely centralized, India's constitutional structure allows both the central government and individual state governments to legislate on employment-related matters. This dual legislative authority has historically resulted in a dense compliance landscape requiring organizations to interpret and comply with multiple laws simultaneously, often with overlapping or inconsistent provisions. But a major shift occurred on 21st November 2025 when the four consolidated labor codes covering wages, social security, industrial relations, and occupational safety and working conditions were brought into force, which repealed and replaced key employment legislations. That said, as is often the case with large-scale legislative reforms, the real challenge lies not merely in the enactment of the law, but in its interpretation and implementation. Organizations across sectors are currently navigating practical questions around compliance structures and the operational impact of the new regime. Many stakeholders are also assessing how existing employment practices must be adapted to ensure alignment with the new legal framework. And today's session is exactly designed to help you unpack these issues. Our panelists today will share practical insights and examine how organizations can approach compliance strategically rather than reactively. Our goal is to ensure that you leave this session with a clearer understanding of what has changed, what remains to be clarified, and what steps you may need to consider within your own organization. Today we have with us Mr. Anshul Prakash and Mr. Vaibhav Bharadwaj. They both are experts in this subject matter and bring decades of experience advising employers on the full spectrum of Indian employment law issues. They are known for their practical, solution-oriented advice and have worked with clients across industries, from startups and MNCs to promoter-led businesses. So without further ado, let's start the discussion. Vaibhav, if I may start with you, while I touched upon that the codes have now come into effect, could you just throw some light on what brought about the four labor codes and what has predominantly changed? And specifically, what is the present enforcement status of these labor codes?
Sure, Vidushi. To understand what led to the introduction of the four labor codes, it's important to look at the earlier legal landscape. Prior to these reforms, employers had to navigate more than 50 central labor laws, along with numerous state-specific statutes and rules, many of which applied simultaneously. This created a compliance framework that was not only administratively burdensome, but also legally complex, requiring employers to reconcile various definitions, thresholds, registers, and filing obligations, sometimes even for the same category of employees. Against this background, the government introduced the four labor codes to consolidate and rationalize the existing framework. Effective 21st of November 2025, the Code on Wages, social security, industrial relations, and occupational safety were brought into force, barring certain administrative provisions. In doing so, 29 central labor statutes have now been subsumed into these four comprehensive codes. The overarching objective is to simplify compliance, promote ease of doing business, and simultaneously strengthen worker protections in line with the needs of a modern workforce. Although these codes were enacted between 2019 and 2020, their implementation was staggered and delayed, which meant that many employers were taken by surprise when they were suddenly brought into force in November 2025 without a clear lead up timeline. In terms of current enforcement statutes status, while the codes are formally in force, the operationalization of several provisions, particularly on the compliance side, still depends on detailed central and state rules. These rules will prescribe procedural aspects, coverage thresholds, and limits for certain statutory benefits. Until these are finalized, only provisions that are self contained and do not depend on subordinate legislation can be implemented in practice. For example, the revised definition of wages for statutory computations, timelines for wage payments, and restrictions relating to contract labor and core activities. Recently, the central government has released FAQs and draft rules for all four codes. The central draft rules are presently open for public consultation and comments from stakeholders.
Thanks, Vaibhav. This has certainly been quite a journey that we have come to this level. Now, FAQs also would be quite helpful, but let's look at the final rules once they come in play. Actually, among other things, you also mentioned the revised definition of wages, which is one of the most talked about provisions. Anshul, if I may request you to explain what this revised definition of wages is and what its impact would be.
Thanks, Vidushi, and I think that takes us to probably the most discussed and impactful changes under the labor codes, which is the new definition of wages. And just to put simply, wages refers to all remuneration that an employee receives in ordinary course in return for the work he or she does. The definition is intentionally broad, but it also lists specific exclusions such as house rent allowance, conveyance allowance, value of housing accommodation, commission, and similar components, which, if structured correctly, may fall outside the wage computation. Now, the key principle to remember here is this. If a payment is promised under the employment contract or terms of appointment as a consideration for performing agreed duties, it will typically qualify as wages. Conversely, discretionary payments, contingent payouts, or incentives that require performance beyond contractual duties on certain additionally agreed parameters or objectives or business goals would fall outside the scope of wages. Now, this distinction matters because many statutory benefits such as provident fund, gratuity, statutory bonus, and other social security entitlements are computed based on what are the wages earned by an employee. So as a result, compensation structuring for any organization now directly affects both employer cost and employee benefits, and that is why several organizations are currently reassessing salary structures for ensuring compliance and also mitigating any additional exposure to liability in terms of gratuity and other payouts. Now, the concept becomes easier to understand visually, which is what the next slide illustrates through a Venn diagram. So as shown on the slide, total cost to the company can broadly be divided into two categories. The remuneration which is paid to an employee and other costs incurred by the employer in relation to the work performed by an employee. Now, within the remuneration section, there is a further split between components that qualify as wages and components that are expressly excluded from wages under the labor codes. But the law, as it stands today, introduces an important rule here. If wages constitute less than 50% of the total remuneration which is earned by an employee, then for the purposes of statutory calculations, wages will be deemed to be 50% of the total remuneration. Most importantly, this does not mandate restructuring of salaries of employees. So it is not the law which is asking you to restructure. Instead, it affects how certain statutory payments, specifically gratuity or even retention compensation, must be computed. For example, if wages are below 50% of the total remuneration, gratuity must still be computed on at least 50% of the total remuneration amount. But if wages already exceed 50%, then calculations are based on actual wages, of course, subject to statutory limits. Currently, the existing gratuity ceiling is rupees 20 lakhs, and that continues until we have a revised limit notified by the central government. For payments such as leave encashment or notice pay, employers will be required to harmonize the statutory requirements which are applicable under central laws and even the existing state laws. So quickly moving to some examples, just to ensure that we show how remuneration is structured under the code. And as you would see, basic salary, DNS allowance, medical allowance, and education allowance, not really specific to any organization, but in general, would all form part of wages. House rent allowance and conveyance allowance are especially excluded components. Now, in the example which is in the slide, the wages bucket or the wages categorization is less than 50% of the total remuneration, which is the sum of wages and expressly excluded components. Now, in this case, the code would notionally take some portion from the expressly excluded components and add it to the wages bucket to bring it up to 50% level. But on the next slide, we have reversed the scenario. In this case, the wages bucket is already more than 50% of the total remuneration amount. So in this case, the whole premise of 50% as base in terms of what should be the wages bucket will not even apply. So your gratuity computation, retention compensation will be computed on the actual wages.
And thank you, Anshul. That was very helpful in breaking down the revised concept of wages. But in fact, actually, it will be very interesting to see how this 50% rule plays out in practice and how businesses adapt to it. So let's see how it plays out. I'm sure sector specific and employee level considerations will also become relevant there.
Sure.
Weber, building on that, could you walk us through some of the key changes introduced under the Code on Wages, particularly around minimum wages, payment timelines, and bonus eligibility?
Thank you, Anshul, for taking us through the revised definition of wages. So apart from the revised definition of wage, the Code on Wages introduces a few other important changes that employees should be aware of. First, on minimum wages. Earlier, minimum wages were prescribed only for scheduled employments. The code now shifts to a universal framework where minimum wages may be fixed for all employments and introduces the concept of a national floor wage to be determined by the central government. States must set their minimum wages at or above this floor level, which is being fixed by the central government. Based on recent government consultations, we understand that different floor wages may be notified for different states, taking regional factors into account. The draft wage rules also classify occupations into unskilled, semi-skilled, skilled, and highly skilled categories. In assessing the floor wage, the central government is required to consult the Central Advisory Board and consider factors such as food, clothing, and housing needs of a standard family comprising 3 adult consumption units. The board's recommendations are then shared with the state governments for consultation. Second, the code removes the earlier 24,000 wage ceiling that applied under the payment of wages framework. As a result, provisions relating to timelines for payment of wages and permissible deductions will now apply to all employees, including managerial personnel. Practically, this means that wages due to existing employees must be paid within 2 working days of cessation of employment. However, an important clarification, this 2-day timeline applies only to wages as defined under the code and not to all components of final settlement. Payments such as gratuity, leave encashment, or other contractual dues may follow their respective statutory or contractual timelines. The last significant change is with respect to statutory bonus. By way of brief background, statutory bonus is a legally mandated annual payment that eligible employees must receive from their employer under labor laws. It is distinct from discretionary or performance bonuses because it is not optional. It is a statutory entitlement triggered when prescribed eligibility conditions are met. The purpose of this bonus framework is to ensure that employees share in the financial performance of the establishment, subject to minimum and maximum limits set by law. Under the previous regime, eligibility for statutory bonus depended on whether an employee's salary fell below rupees 21,000 per month or not. If yes, the bonus payable ranged between a statutory minimum of 8.33% of wages and a maximum of 20%. And that depends on the allocable surplus of the establishment. These percentages were fixed and continue to be the benchmark for calculation. The new code retains the same minimum and maximum bonus percentage, that is 8.33% to 20%. So the fundamental payout structure has not changed. However, the key shift is that the salary eligibility threshold will now be notified separately by the appropriate government rather than being hard coded into the statute. This means the threshold may be revised more flexibly in future without legislative amendment. Until a new threshold is notified, the previous threshold of INR 21,000 will continue. This means that if the wages of an employee is rupees 21,000 or less per month, even if their gross take-home salary is more than INR 21,000 per month, they will be entitled to statutory bonus subject to few other conditions mentioned under the wage code. The last important change is that the law now expressly provides that an employee who has been convicted of sexual harassment will be disqualified from receiving statutory bonus. This is a new disqualification ground that did not exist explicitly under the earlier framework.
Thank you, Vaibhav. I think from bonus perspective, while percentages you mentioned remain the same, the salary eligibility threshold may differ basis what governments notify. So I guess it will be easier to amend also instead of requiring the entire law to be amended. So in future that is a possibility. Okay. And Anshul, if you could walk us through the key changes introduced under the Code on Social Security, particularly what's changed for employers in terms of coverage, benefits, and compliance obligations.
Sure. So, the Code on Social Security 2020 has replaced as many as 9 previously existing central statutes. Just to name some of the key replaced statutes: the ESI Act, the Employees Provident Fund Act, Maternity Benefit Act, and Payment of Gratuity Act 1972. While the Social Security Code and Occupational Safety, Health and Working Conditions Code have registration requirements for covered establishment, just needed to highlight that your existing registrations under the previous regime will continue to remain operational. There may be some additional information requirements, but that will be subject to the central rules under the Code on Social Security as and when these are made effective. So, coming to the point of definition of wages, because again, that is going to impact the calculation of employee payouts such as gratuity. But as far as provident fund contributions are concerned, the impact would be limited to employees who fall below the currently stated statutory wage ceiling for contributions. So just to give a quick example, if the central government eventually continues to retain 15,000 rupees per month as the statutory wage ceiling, and an employer is already contributing at that level, then no restructuring may be required from a provident fund liability standpoint. Of course, since final notifications under the codes are still awaited in terms of the ceilings and statutory coverage requirements, the current ceilings and limits which are prescribed under the previous regime will continue to apply even now. A key nuance under the Social Security Code is this. Although the new definition of wages is already in force and must be used for computing payments under the Social Security Code, the previously existing statutory ceilings for benefits and contributions, specifically those for employees' provident fund and gratuity payment, may continue to be relied upon until revised limits are formally notified by the central government. So in practical terms, this creates a transitional phase where employers must apply the new computation base, but the old monetary caps, which requires careful payroll calibration and compliance monitoring. And this is very important because another point to highlight here is that under the erstwhile regime, inclusion of contract workers within the definition of an employee was limited to employees' provident fund contributions and employees' state insurance fund contributions. However, now contract workers are also included within the definition of an employee, even from the viewpoint of payment of gratuity. So the lines have blurred further. But in any case, the contractual arrangements can be put in place to make the contractor primarily responsible for these payouts, and the principal employer, that is the establishment which is receiving those services through deployment of outsourced workforce or contract workers, it can be ensured that the principal employer remains indemnified in case of any administrative action which requires to be taken to recover any amounts for which the principal employer has been held liable. Now, this again brings us to another important change, which is express recognition of fixed term employment across establishments. Under the previous regime, the engagement of fixed term employment was expressly recognized under the model standing orders, which were contained in the central rules framed under the Industrial Employment Standing Orders Act. Now, this statute, the previously existing statute, applied mostly to industrial establishments that were categorized as factories, with very few states extending this statute to commercial establishments. Now, under the current regime, irrespective of the nature of the establishment, fixed-term employees are entitled to at-par treatment in employment terms in line with permanent employees who are doing the same work. Another important point to consider here is that the fixed-term employees will be entitled to gratuity in case of expiry of contract, notwithstanding the fact that such fixed-term contract employee has not completed at least 5 years of continuous service. So they will receive gratuity on a prorated basis depending on their tenure with an organization. Just to again bring in a very important point, because this is about that upcoming draft central rules. Now, under the draft central rules related to Code on Social Security, they do suggest inclusion of a minimum 1-year criteria for a fixed term employee to become eligible to receive gratuity. Other than this, one more important and very critical change, probably from industry viewpoint in general, is application of a limitation period of 5 years for the authorities under the Provident Fund regime to conduct inquiries against establishment in relation to any statutory non-compliance. Now, under the previous regime, authorities, Provident Fund authorities had the power to ensure that they can have a look back period of maybe extending to 10 years to 15 years. But now there is a limitation period which restricts the look back period to only the last 5 years from the date when the inquiry has been initiated.
Thanks, Anshul. I think that limitation period may help make the regime little more limited, in the sense you have some timeline there. And you also touched upon the fixed term employment, that expanding that to all industries will certainly draw some interest from the industry in terms of implementation, I suppose. Thank you so much. Vaibhav, given these changes, a common question is whether the SS code increases the overall cost of employment. And cost of employment is always a topic of interest to all the organizations. So, should employers expect a real increase in contributions, or is the impact largely neutral? Similarly, what could be the impact on employees? Would their take home salary or their rights be impacted? I think that is one of the most crucial question for everyone here today.
Thanks, Vidushi. In fact, this is a question that we are hearing quite frequently from employers and employees. From an employer's perspective, the impact of the Social Security Code is not uniform. It is largely organization specific and depends on how compensation structures are currently designed. For employers whose salary structures rely heavily on allowances and have a relatively smaller portion classified as wages, there could be an increase in statutory contribution outflows because certain exclusions may be classified for computation purposes. On the other hand, organizations whose pay structures are already broadly aligned and wages are in the range of 50% may find the impact largely cost neutral. Importantly, the law does not mandate salary restructuring. Whether or not to redesign compensation structures is ultimately a strategic decision for each employer, requiring a balance between legal compliance, cost considerations, and transparent employee communication. From the employee's perspective, the revised definition of wages primarily affects how statutory benefits and payments such as provident fund, gratuity, and similar entitlements are calculated. In some cases, employees may experience a short-term reduction in take-home pay, particularly where higher contributions are triggered. However, this may offset by higher long-term benefits, since many Social Security payouts are linked directly to wage levels. In addition, the code strengthens employee rights in certain respects. For example, by clearly recognizing fixed term employment and ensuring parity of benefits between fixed term and permanent employees performing the same work. Also, since the substantive provisions on fixed term employment are not contingent on government rules and notifications, organizations can initiate a review of their current engagement practices as far as entitlements of fixed term employees are concerned.
Got it, Vaibhav. Actually, you mentioned that law does not mandate salary restructuring. But are you seeing companies assessing whether restructuring the wages would be beneficial? In fact, one of our audience listeners have asked, is there a maximum timeline by which this should be done? Do you see any of that?
So restructuring is something, as I mentioned, restructuring is something which is not required. You typically restructure the salary to reduce the financial impact. And of course, basis the initial wage assessment that you have undertaken to understand what will be the financial impact. And if at all the organization is of the view that the restructuring is required, then of course there is no timeline to it. But from the implementation or of the codes, or since when you have to start looking at the new definition of wage, that is 21st of November 2025. So ideally, whatever payouts are being made, whatever calculations are being done, should be done basis the new definition of wage after 21st of November 2025.
Got it, got it. Thank you so much, Vaibhav. So we've now discussed the wage and social security reforms and their practical implications. Turning now to workforce relations, Anshul, if you could walk us through the key changes introduced under the Industrial Relations Code, particularly how it reshapes employer obligations around workforce management, dispute resolution, and trade union engagement.
Sure. Thanks, Vidushi, and thanks, Vaibhav, for covering a very important point because even from industrial relations standpoint, several questions have been raised on the larger restructuring part. So I'll just go through some of those key changes under the Industrial Relations Code, which introduces several structural changes that tend to significantly reshape how employers manage workforce relations, compliance, and dispute resolution. So, just to begin with, the code consolidates and replaces three major statutes: the Trade Unions Act 1926, Industrial Employment Standing Orders Act 1946, and Industrial Disputes Act 1947 into a single unified legislation. Now, this consolidation is intended to simplify compliance and bring consistency to the larger regime which governed industrial relations in the past. Now, in terms of applicability, just like how the earlier framework used to work, the code applies only to workers, which broadly corresponds to the concept of workmen under the previous regime. Just one important distinction from the earlier concept of workmen is the revised wages threshold for personnel who are engaged in supervisory capacity. Now, under the previous regime, supervisory capacity individuals who earned more than 10,000 rupees per month were excluded from the coverage within the ambit of definition of a workman. Under the new framework, which is the Industrial Relations Code, this threshold has been increased to 18,000 rupees per month as wages. And that is how the law perhaps is now intending to expand coverage of a bigger category of employees. Another key change relates to standing orders, which govern service conditions for non-managerial personnel, that is the workers. And some of the key elements of standing orders also covers disciplinary procedures apart from other service conditions. Now, previously, these requirements applied primarily to industrial establishments such as factories, mines, and plantations, which were employing 100 or more workers at any point in time. Some states in India had reduced this threshold. Now, under the new code, which is the IR code, the standing orders chapter applies to all establishments, and that includes even a commercial establishment once that establishment reaches the threshold of 300 or more workers. So, covered establishment under the new regime will be required to either adopt the model standing orders, which will be issued with finality by the central government once the central rules under IR code are made effective, or the establishment needs to obtain certification of their standing orders from the appropriate designated authority. Typically, in this case, the state government will be the appropriate government for private establishments. The code also introduces a procedural change in dispute management. This is important because under the earlier regime, if an employer already had a grievance mechanism in place, it was not mandatory to constitute a formal grievance redressal committee, a GRC. The Industrial Relations Code, however, now mandates such committee for covered establishment. That means those establishments which have 20 or more workers engaged at any point in time. Now, this grievance redressal committee must include representatives of both employer and employees. Interestingly, decisions must be based on majority view, provided that more than half of the representative from workers' side would agree to that majority view. If that condition is not met, the law treats it as a situation where no decision has been reached. So this is something which is very important for especially those establishments which have unionized workforce to consider. The code also introduces other important changes related to workforce restructuring, engagement with unions, and industrial actions. The first one is in respect of closures, layoff, and retrenchment approvals. Now, under the earlier framework, factories, mines, and plantations engaging 100 or more workmen were required to obtain prior government approval before undertaking any retrenchment exercise. But some states, of course, under the previous regime had also increased this threshold but it was not a uniformly applicable threshold across India. The Industrial Relations Code raises the threshold uniformly to 300 or more workers. Now, just to clarify, the requirement of seeking an approval from the state government continues to exist, but it applies to only those establishments categorized as factories, mines, or plantation once this higher threshold is breached. And that gives employers greater flexibility in terms of workforce management below that level. The second point is code introduces an additional financial obligation where services of non-managerial employees, that is workers, are retrenched or terminated. So apart from severance or statutory retrenchment compensation, employers are also required to contribute to a worker reskilling fund, which is an amount equal to 15 days wages last drawn by any impacted worker. So this is a one-time payment equivalent to 15 days wages. And again, I'm clarifying it is not 15 days wages for each completed year of service. It is only 15 days wages. Just to clarify, as of date, this fund has not yet been operationalized. The third one is code creates a formal framework of recognition of trade unions, which was largely absent earlier, except in few states. So this whole concept of recognition is now standardized through a verification process, which will be prescribed by the central and state governments through the rules. But just to cover this point about how industrial relations management is going to be in the future, largely from the perspective of how recognition as a concept is now uniformly applicable across all the states at the central level. If there is only one registered trade union, it will be recognized as the sole negotiating union. If multiple unions exist, the union with 51% or more worker representation becomes the sole negotiating union. But here is the catch, there is a third category. If no union has 51% worker representation, there will be a negotiating council which will be formed and comprising of unions that have at least 20% representation from the worker side. So just to again touch upon the point of existing state laws, this whole interaction between the new provisions under the central law regime and the existing state level recognition regime is something that will evolve as implementation of this regime progresses. The final point, the code expands the framework governing strikes and lockouts. Earlier, advance notice and cooling off requirements were limited to those establishments which were engaged in public utility or essential services. Now, similar restrictions, that is a notice requirement of 60 days before taking any action to call a strike, and again a 14 days cooling off period within that notice period is extended to all establishments. So this significantly broadens the regulatory scope of industrial action either on the employer's part or on the employee's part.
Right. I think you touched upon that framework for recognition of trade union. So from employers' perspective, also they'll be looking at it. I'm sure trade unions themselves, in due
True.
course, they will discuss about what will be the implication.
Right.
Okay. So I think we can just touch upon the last labor code, also the OSH code, Occupational Safety, Health and Working Conditions code. Vaibhav, if you can take us through the key changes brought about that code as well, that will be very helpful.
Sure. So the Occupational Safety, Health and Working Conditions Code, it's commonly referred to as the OSH code, is another major consolidation reform. It replaces 13 existing central labor statutes, including key laws governing factories, contract labor, with the aim of creating a unified framework for workplace safety, health, and working conditions across sectors. To start with applicability, most provisions under the OSH code apply to workers, which excludes persons in managerial roles, and supervisory personnel earning more than rupees 18,000 per month. This is a departure from certain earlier laws, such as the Factory Safety Framework, which applied to all employees regardless of designation. As a result, employers now have relatively greater flexibility when structuring working conditions for managerial staff in factories. Another important distinction is that under this code, the definition of worker does not include contract labor, unlike certain earlier frameworks. A major conceptual reform introduced here is the idea of core activity of an establishment. The code restricts engagement of contract labor for core activities, something that previously existed only in a few states and was not part of the central regime. A core activity is essentially the primary activity for which the establishment exists, including activities integral or necessary to it. The law also lists examples of activities generally treated as non core, such as housekeeping, sanitation, loading, unloading, transport, or security, unless the establishment itself is set up to perform these functions. Contract labor may still be used for core activities in only limited situations, such as when the work is intermittent, requires specialized skills, or there is a certain certain workload. So these are the exceptions under which you can engage contract workers. Another notable development is that the code introduces working hours, spread over, and overtime provisions at a central level for establishments beyond manufacturing. Earlier, non manufacturing establishments were primarily governed only by state shops and establishment laws. While the code aims to bring greater uniformity, those state laws will continue to apply, so employers will need to reconcile overlapping requirements and follow whichever provision is more beneficial to employees where conflict arises. On leave entitlements, the code provides workers and approximately 18 days of annual leave with wages if they have worked at least 180 days in a year. It also allows carry forward up to 30 days, encashment of excess leaves, and in service encashment upon request. Since state laws also prescribe leave entitlements, employers must compare both frameworks and apply the one that is more favorable to employees. Another compliance requirement is that appointment letters must be issued to all employees in a prescribed format containing specified details. The draft OSH rules provide a format for the appointment letters, which, along with personal details, includes details such as Aadhaar number, UN, category of skill, nature of duties, etc. If you move to the next slide, in this slide, we have set out few provisions around health and safety. By and large, we expect these provisions to be aligned with the erstwhile regime, barring some changes in thresholds. Another major reform under the OSH code is the extension of welfare facilities. Earlier, welfare facilities were limited to few establishments, which were factories, mines, plantation, BD cigar, dock workers, building under construction workers, and motor transport workers. As a result, large parts of the workforce, particularly those in the service sector, IT/ITES, retail, hospitality, logistics, even financial services and professional services, did not fall within the scope of many welfare related obligations. The OSH code now brings about a sector agnostic framework by extending these welfare requirements to all establishments covered under the code. This marks a major shift towards ensuring uniform minimum standards for employee health, safety, and well being across the entire economy. These include facilities such as washrooms, bathing places, drinking water, health checkup requirement for specific category of employees. And health checkup requirement is specifically for certain category of employees, especially those engaged in work that may expose them to hazardous substances, physically demanding or high risk activities, and occupations notified by the government as requiring medical monitoring. For employers, it implies the need for structured health monitoring programs and tie ups with medical service providers. Employers are also required to create safety committees applicable upon reaching certain threshold of employees.
Thanks, Vaibhav. You mentioned that the prohibition on engaging contract labor core activities is already in force, which could significantly affect organizations that rely heavily on outsourced manpower. So, Anshul, from a practical standpoint, if you could help us understand what should be the immediate risk mitigation steps that employers should be taking to ensure compliance and minimum exposure under this code.
Thanks, Vidushi, for bringing that up because perhaps this is one of the most critical questions before the industry, and especially given that this restriction is already in force. Organizations are required to consider this matter as something which takes priority over anything else other than what we have already discussed in terms of restructuring, is to undertake a structured compliance review of the current contract labor arrangements. This would also involve mapping all outsourced roles against the core versus non-core test, which is currently covered under the OSH code, and assessing whether any statutory exceptions may legitimately apply. So, for example, seasonal work, intermittent requirements, or activities which are ordinarily or customarily performed through contract workers. In parallel, employers, establishments should review existing vendor agreements, scope of work documents, or SOW as we call it. Even deployment structures have to be looked at to ensure that contractual documentation is accurately reflecting the nature of services and it does not inadvertently characterize core functions as outsourced support services. So, where a potential exposure is identified, organizations need to evaluate alternative engagement models, including partial insourcing, even role redesignation or realignment, or even restructuring of service arrangements. The other important point is that while the code restricts engagement of contract labor in core activities, it does not mandate automatic absorption of these workers. So I just want to again clarify that under the OSH code, there is no automatic absorption which is available as an entitlement to contract workers. So risk mitigation needs to focus on compliance alignment and documentation readiness rather than immediate workforce restructuring. So don't jump to that conclusion. Look at what you currently have, and then accordingly, you need to ensure readiness from documentation and compliance perspective. Additionally, employers should also implement internal audit mechanisms and compliance checklists. And that is largely meant to facilitate a scenario where if there is a review by inspector cum facilitator under the OSH code, they can demonstrate good faith compliance efforts and timely corrective action.
Thank you so much, Anshul. That was very helpful. I just want to pick on the point of inspector cum facilitator regime, which you mentioned. If you could just explain what that means and whether that's more employer friendly, Weber, if you could help us understand that better.
Sure. So now there has been a shift and now it's a facilitative regime. So if you look at the earlier label of framework, penalties were relatively low, enforcement was slow, and proceedings often became prolonged and procedural. The new labor codes seek to address this by introducing higher monetary penalties along with a formal compounding mechanism. Compounding allows employers to acknowledge a violation and pay a prescribed amount upfront, typically 50% to 75% of the maximum fine, thereby avoiding protracted litigation. However, this option is not available for repeat offenses committed within a period of 3 years, which underscores the importance of sustained compliance systems.
Thank you so much. I think with these reforms coming into effect in phases, organizations are also keen to understand where they should start. So maybe from a practical compliance standpoint, if you could tell us what are the top priority action items that employers should focus on immediately to stay ahead of risk. Anshul, if you could throw some light on that, please.
Thanks, Vidushi. I think on the practical side of things, I'll just cover matters which are of immediate priority. So the first is remuneration structure review or wage structure review. Organizations need to first assess their salary structures to evaluate what is the impact it has on from the perspective of revised definition of wages as far as any statutory payment such as gratuity, retrenchment compensation, leave encashment is concerned. And this is particularly for employees who have exited the establishment on or after 21st November 2025. The other important point is coverage assessment, which involves conducting a workforce-wide analysis to determine mandatory coverage of personnel under EPF, ESI, and statutory bonus regime. And that is largely based on the revised definition of wages because eligibility thresholds and contribution basis may shift. Final settlement timelines are also equally important to be revisited because you need to ensure that systems are aligned to enable payment of wages to all employees, and even leave encashment for workers have to be paid within 2 working days of exit, which is a requirement under the codes. The other important point is contract labor engagement practices review. So you need to carry out an audit or an internal assessment of your existing third-party manpower service arrangements to identify whether contract labor is engaged on the premises in core or non-core activities and accordingly evaluate compliance risk or restructuring needs. The other important point is working hours and leave harmonization. So you need to compare organizational policies with both the OSH code requirements in mind and also keeping in view the currently existing applicable state shops and commercial establishment regime. And accordingly, you need to align with whichever provisions are more beneficial for the workers. So these are the few points where you need to probably take it up as a matter of priority.
Thank you so much, Anshul. And thank you so much, Vaibhav. It has been quite insightful to understand the new regime ushered by these four codes and how, in fact, it borrows from or maintains the old regime while taking meaningful strides ahead. And across the spectrum of wages, labor compliance, and industrial relations, we'll definitely witness practical challenges. Businesses will want to solve the most in the most commercially feasible manner. So it is some interesting times ahead of us. I have already tried to cover quite a few of questions which were being posed by the audience, but there are quite a few more. So let me just try and pick your brains on a few of those questions. First one, let me take a question which is on the key implementation risks or uncertainties that leadership teams should monitor from now on. Vaibhav, if I may request you to throw some light on that, please.
Sure. Uh, Implementation timelines and compliance requirements may vary significantly across states. This could create a transitional complexity specifically for multi-state employers. There may also be initial interpretational issues around the wage definition, social security coverage for new category of workers, and procedural requirements under the codes. Leadership team must take a phased readiness approach, prepare internally while monitoring regulatory developments.
Got it. Thank you, Vaibhav. And I'm sure, a lot of queries would be coming your way on all these points. So, got it. Anshul, I think you touched upon the existing registrations, licenses, and whether those will continue to be valid. And there is another related question that will the employers be required to obtain fresh registration licenses? If you could confirm on that.
Sure. So more on the procedural side, there is no requirement to obtain fresh registrations or licenses. These will continue, as I've already clarified. Labor codes do envisage migration to a common registration framework once the rules are in force. Uh, of course, transitional provisions are expected to protect what you already have as an existing registration. So there may be some additional requirements to furnish some information, which could be a requirement under the rules once these are in force, but existing registrations will not be impacted.
Got it. And then from your experience, Anshul, what are the most common misconceptions employers have about labor codes that need to be addressed early as possible?
I think that's very important because uh, probably the most important one in terms of misconception is whether the labor codes are in force or not. Because everybody probably takes the term being in force and being implemented fully or procedurally in the same stride. But I would like to clarify that the codes are very much in force. And also the other point which industry is carrying as a misconception is that a belief that restructuring of wages is something which is mandated across the board. And another important point is where you underestimate the state level variations because the state laws, the state specific Shops and Commercial Establishments Act continue to remain in operation. So that's something which you cannot ignore, and ignoring that is another misconception.
Thank you for that. Uh, Maybe we are running out of time, so I'll just ask one last question. Vaibhav, if you could let us know on this question, it talks about M&A. So, do the labor codes have impact on ongoing or future M&A deals? And how should the labor codes be factored in while dealing with global cross-border deals?
Yes, of course, there is an impact on M&A deals as well. There is, of course, an increased diligence focus on workforce data and statutory exposure, including the revised competition for statutory contribution payouts. So this I would say is one of the biggest impact which one should be mindful of as part of any diligence exercise that is being undertaken. Apart from that, cost modeling and assessment of cost under the new wage definition, because the entire P&L would change basis the new wage definition. So that's also a bigger impact. Thirdly, of course, transitional risk where implementation timelines are uncertain. A lot of organizations are adopting the wait and watch model. They are uncertain about the timelines for implementing these changes. So from that perspective, also one need to be mindful that too much of delay in terms of implementation may increase the risk and increase the financial liability as well.
Thank you so much. These were definitely very, very pertinent, questions, and the way you both have answered those, keeping your, sharing your expertise and experience with us today. Thank you so much for that. It was simply outstanding. And it has certainly been a thought-provoking discussion. I hope everyone in the audience also found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you all. Thank you so much, audience, for your attention and your questions. After the webinar, we will send to you a copy of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and even compliments. The form takes less than 1 minute to complete. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slides at the end of this webinar. And thank you for your attendance today. And we look forward to being with you again at In-House Council Forum. Thanks a lot.